In today's video, we will talk about criminal justice stages from arrest to bail to arraignment. Hello, and welcome to Ask Professor Price. I have been a lawyer for more than 35 years and a full-time professor for more than 10 years. People studying law or criminal justice or working in the legal or law enforcement fields need to know how a criminal case progresses from the point a person gets arrested. We will talk about the initial appearance, bail, the preliminary hearing, and the arraignment. So let's jump right into criminal justice stages from arrest to bail to arraignment. More than 10 million arrests every year in the U.S. are for non-traffic offenses. So this does not include speeding tickets and other traffic violations. Of these arrests, vast majority of them are for what are considered minor crimes, and fewer than 20% of the non-traffic arrests every year are for serious crimes like homicide, robbery, arson, aggravated assault, rape, and auto theft. By the way, the relatively minor crimes, the more than 80% of total non-traffic arrests, include things like possession of small amounts of illegal drugs, simple assault, petty theft, disorderly conduct, and public drunkenness. The actions of the police at the time of the arrest and during the investigation are major factors in whether the prosecutor will be able to secure a conviction at trial. How the police collect evidence, if they don't follow the rules, it could prevent evidence from being able to get used at court. The prosecutor might not have the admissible evidence that they need at trial. Also, if the defendant's rights are violated during the arrest, the judge might dismiss the charges. And how the police interact with witnesses also can affect whether they're cooperative, whether they're willing to testify at court, whether they're willing to tell the truth at court. If they feel that they were treated coldly or callously by the police, they might feel they have no reason to help the police. If they have distrust of the police, the witnesses might not want to help. So, after an arrest, usually the first thing that happens is the initial appearance. This usually happens within a few hours or a few days of the arrest, depending on the day of the week and holidays and similar things. If the courts are not open or if they only have a skeleton crew, it can take a little longer to process people. The Supreme Court ruled that an initial appearance must happen within 48 hours of a person being arrested. This does not include Saturdays and Sundays because few people are at the courthouse working on the weekend. Most of the defendants who get charged with misdemeanors plead guilty at the initial appearance. They get sentenced at the same time, and boom, it's over, and they can get on with their lives. Unless, of course, they have to go to jail, but for misdemeanors, people often get a fine and probation. That depends on the misdemeanor and any criminal record the defendant might have. On the other hand, defendants who get charged with felonies cannot enter a plea at the initial appearance, so their initial appearance hearings are even briefer, even more brief. There are several different kinds of charging documents. Charging documents are when someone gets charged with a crime, it involves paperwork. The paperwork can be called a complaint. It can be called an information. If a grand jury was involved, it could be an indictment. Or it could be an arrest warrant that specifies the particular charges the defendant is being charged with, the specific offenses. Most people don't realize that just because someone gets caught committing a crime, they won't necessarily get prosecuted for that crime. This is not how it works on TV, I know, but in reality, there is just no time for a criminal justice system to handle and prosecute and take to trial every single possible crime committed by every potential defendant. So the first point of discretion is with the prosecutor. The prosecutors get to pick and choose which defendants will get charged with crimes and with which crimes they will charge a defendant. So let's say that there is evidence that 4 people might have been involved in the commission of a crime. Let's say a group shoplifting. The prosecutors get to pick and choose which defendants they're going to charge with that group shoplifting. And they get to choose what they'll call the criminal offense. Will it be shoplifting or will it be something more severe or less severe? Did they use force? Did they act with violence against other shoppers or against a clerk? Did they resist arrest? Prosecutors are the first line of discretion on weeding out what goes forward from that point. Courts will give prosecutors wide discretion on those decisions, and there is no review of those decisions. Let's say that the store owner said, hey, there were 4 people involved in the mass shoplifting or doing this as a team. How come you only prosecuted 3 of them? The victims don't get to demand who gets prosecuted or what charge, which offense they get charged with. Depending on the jurisdiction, out of all the people who get arrested for felonies, up to half of them do not get formally charged with a crime at all. So it doesn't even start at the point of prosecution. The next stage is bail. Judges have wide discretion when they set bail. It's a case-by-case basis. Judges consider multiple factors. One of them is the risk of harm to others or the risk of harm to the defendant. Another factor is situational justice, meaning unique aspects of this case. And part of the situational justice is, has there been public outcry? Was someone videotaping the entire incident and posted it on social media? Also, what is the risk that the defendant will flee the jurisdiction and not come back to court for subsequent hearings? They might not physically flee the geographic area, but if they go underground, the law enforcement officers might not be able to find the person for them to come back to court for a later hearing. So judges consider factors like these when they decide if they're going to grant bail, and if so, what type and how much. There are multiple types of bail. A lot of people are released on their own recognizance, called ROR. Being released on one's own recognizance means the judge basically gives the defendant a brief, stern lecture that they need to come back to court and if for the future hearings, and if they don't, they can get arrested again and have additional charges added to their case. So that is being released on the defendant's own recognizance. They don't have to post money or property or a bail bond. The other types of bail are a cash bond. Let's say it's a $100,000 cash bond that they might have to post 100% of, or the judge might say they have to post 10% of it. Also with property bonds are how basically the grandmothers of a lot of young defendants end up losing their houses. The judge orders a certain amount of bail, and the grandparent or parent might put up their own property as security for their child or grandchild returning to court, and if they skip out on bail and do not come back to court when they're supposed to, the person forfeits that property. And bail bond is when a defendant will buy a bail bond from a commercial agency, a bond agency, that will serve as security for them to come back to court when they're supposed to. It is often 10% of the amount of ordered bail that the defendant pays to the bail bonds person or bail bonds agency. If they do not show up at court, the bail bond gets forfeited. If they do show up at court, they still lost their money that they paid for the bail bond, but they're not on the hook for the 100%, at least directly to the court. The bail bond company is. That's why you see in a lot of movies that bail bonds agents go hunting after fugitives, and they say that someone has a price on their head. It's usually the bail bond company going after them. So those are the 4 types of bail: released on the defendant's own recognizance, cash bond, property bond, and bail bond. Please hit subscribe and the thumbs up icon if you enjoy this video. Also, please feel free to share this video with people you think could benefit from the information. YouTube uses the number of subscribers, likes, and shares in its algorithm to determine which videos show up in search results, and the higher these videos are in the results, the more people I can help. Thank you. So what happens to defendants who are denied bail or who can't afford to pay bail? They have to stay in jail until the trial. That can be months later, depending on certain delays. It could even be more than a year later. A lot of people now question if it is fair or constitutional to keep someone in jail for purely economic reasons if they would otherwise be a good candidate for pretrial release. For example, if a person is poor and they have allegedly committed a minor crime and the judge ordered $10,000 bail, they don't know how they're going to pay their electric or water bill that month, much less cough up $10,000 magically out of thin air. But a person who is employed and earning a good wage or salary might be able to come up with $10,000 bail, and this would be someone who had committed the exact same crime as the person who is unemployed or otherwise financially challenged. So both people committed the same crime. One can afford to pay the bail out of their assets or savings, or can qualify for a personal loan, and the other person cannot. Is it fair or constitutional to keep someone in jail purely for that economic reason if they would otherwise be a good candidate for pretrial release. Also, pretrial release orders can include non-financial conditions. It's not just pay the money and get out of jail until trial. Pretrial release orders can include limitations on the defendant's access to firearms. It can include restrictions on travel. It can involve court-monitored supervision. They might require a monitor, a tracking device that might be on the person's ankle. It might involve having to complete drug, alcohol, or mental health treatment. Those kind of conditions can be highly useful. When they come to trial and sentencing, they might have already completed what they would be sentenced to, and so by the time their case reaches trial, they're pretty much home free after that, rather than having to start doing the actions that the judge would order. They might have most or all of them completed at that point. One of the next stages is the preliminary hearing. At the preliminary hearing, the prosecutor must show probable cause that the defendant committed the crime. So that's two parts to that burden. They must show that someone committed a crime. And they must show that the defendant was the one who committed it. Now, not beyond a reasonable doubt, that is the burden of proof of the prosecutor at trial. But at the preliminary hearing, they must at least show probable cause that the defendant committed the crime. Otherwise, the case cannot go forward to trial. The prosecutor might request additional time to investigate, to come up with the evidence that would satisfy the judge of probable cause. Judge might or might not grant that request. It might be that the charges get dismissed. It really depends on many factors, including how close the judge thinks the prosecutor is to being able to establish probable cause. Then there's the arraignment. At the arraignment hearing, the defendant gets formally accused of a crime in the trial court. The defendant enters a plea of guilty or not guilty. If they want to get a trial, they must plead not guilty, because the whole purpose of a trial is to determine guilt or innocence. If they plead guilty at the arraignment, there will be no trial. The case will then proceed to sentencing. So that takes us from the stage of arrest to bail to arraignment. Please feel free to post in the comments your videos about criminal law or related topics that you would like to see covered in a future video. I cannot provide legal advice about specific cases or situations, but I can offer general legal information for educational purposes. Law students, paralegal students, criminal justice students, and pre-law students, as well as people working as paralegals or in the criminal justice field, are the main audience for these videos, but everyone is welcome to learn about American law and our legal system. Please remember to subscribe so you can get notifications when I post a new video. Subscribing won't cost you anything, but it can help me to reach and help more people with these educational videos. Thank you. If you liked this video, you might like the next video, Crime Statistics, the UCR and NIBRS Crime Statistic Reporting Systems.